there, deep divers. Ever wondered about the hidden dangers lurking in some everyday products or, the invisible threats from industrial processes? We're talking about substances that can cause injury, ill health, or maybe even worse. Today, we're taking a deep dive into a piece of legislation that, well, it acts as a kind of silent guardian against these very risks. The Hazardous Substances Act of 1973. Now, this isn't just some dry legal text. It's actually a living document that's been protecting us for decades, and it keeps evolving.
Right.
We're going to unpack this consolidated act, which basically means it's been updated and, tweaked over the years to bring in amendments and keep it relevant. So whether you're just a curious citizen trying to understand the world around you, or maybe a law student looking to get a handle on the practical side of regulatory law, this deep dive is definitely for you.
That's absolutely right. That's our mission for this dive, really. We'll explore the fundamental purpose of this act, trace its key provisions, sort of place it in its wider legal context, and then really dig into its practical implications. Ultimately, we want to reveal its real-world significance. We'll use clear language, the relevant legal terms, of course, but also some examples to make it stick. It's about understanding not just what the law says, but really why it matters and how it, directly impacts our safety day to day.
Okay, yeah, let's unpack this then. So, when you look at the Hazardous Substances Act of 1973, what was the big picture? What problem was it really created to solve back then?
Well, at its heart, the Act was designed to provide a pretty robust control system. It covers substances and also specific electronic products that pose a significant risk to people. And this isn't some vague concern. The Act actually calls out risks from things being toxic, corrosive, irritant, strongly sensitizing, flammable, or even things that can generate pressure. It's intended as a comprehensive shield, really, aiming to protect public health and safety from a whole spectrum of dangers. You can think of it like this. The Act steps in to manage anything that, even through just normal customary handling or use or maybe even ingestion, could potentially cause injury, ill health, or, well, death. And this isn't just for, massive industrial chemicals. It applies across the board from ingredients and consumer goods right through to certain medical devices. It sets a baseline for safety.
Okay, what immediately jumps out at me there is you said electronic products. It explicitly mentions risks related to electronic products. Wait, electronic products back in 1973, that sounds incredibly ahead of its time. What kind of electronic risks were they even thinking about then?
Yeah, you're right to pick up on that. It was remarkably forward-thinking for the time. I mean, in 1973, personal computers weren't really a thing yet, but this act was already talking about electronic product radiation, things like X-rays or microwaves. It shows a really deep understanding, I think, that technological progress brings new hazards, often invisible ones, long before they become everyday concerns. It's really a testament to the foresight of the drafters, anticipating dangers that were still very much emerging at that point.
That's quite something. They weren't just reacting, but actually setting up a framework for future issues. Okay, so to control these varied dangers, the Act doesn't just lump everything together, it divides them into different categories, right? Can you walk us through these grouped hazardous substances? What makes each group distinct?
Absolutely. Yeah, the Act sets up 4 distinct groups. This lets them tailor the control measures based on, the type and level of danger involved. It makes sense. So first up, we have Group 1 and Group 2 hazardous substances. These are probably what most people think of first substances or mixtures that are toxic, corrosive, irritant, strongly sensitizing, flammable, or that generate pressure. The minister who has the overall authority formally declares which specific things fall into these groups. Think industrial solvents, strong cleaning chemicals, maybe certain pesticides. Then there's Group 3 hazardous substances. As you pointed out, this is where the electronic products come in. Now, an electronic product here is defined pretty broadly. It's any manufactured product that, when it's operating, gives off electronic product radiation like X-rays from medical gear or microwaves from ovens, like we mentioned. But importantly, it also includes products that could pose other hazards: electrical, mechanical, chemical, biological, even ergonomic issues, or excessive heat, pressure, or setting flammable stuff alight if their built-in safety systems fail. It's a really wide net covering lots of potential failure points. And then we get to Group 4V hazardous substances. This is where it gets really interesting for a lot of applications. This group deals specifically with radioactive material. But, and this is a crucial distinction, it's about radioactive material outside a nuclear installation. So we're not talking nuclear power plants or weapons here. We're talking about materials used in hospitals, say, for medical imaging, or in labs for research, or maybe certain industrial gauges. The Act actually sets specific thresholds for activity concentration and total activity for materials to fall into this group. It makes sure the focus is on items posing a practical risk in more everyday settings, not just theoretical ones. It even covers the radioactive waste that comes from using these materials.
Ah, okay. That's a really vital nuance. So Group 4 isn't about the big nuclear facilities, but more the radioactive materials used in, say, cancer treatments or maybe in a university research lab. Maybe even some types of smoke detectors. It really connects this old act to technologies that are very much part of our modern lives.
Precisely. It brings the regulation right down to earth, you could say. Covers things people might actually encounter.
Okay, so we've got these dangers sorted into categories, but just having categories isn't enough, right? How does the legal framework actually manage them? Let's sort of trace the journey of a hazardous substance from when it might first enter the country, through its use, and then how it's finally disposed of. What's the actual scope of the Act's control here?
That's a great way to frame it, thinking about the whole life cycle. The Act sets up a very broad control framework covering, well, pretty much every stage: importation, manufacture, sale, use, operation, application, modification, disposal, or even dumping. It's meant to be a holistic approach to managing risk, catching potential problems at any point. And one of the main ways it does this is through licensing and authorization.
You're right. So it sounds like you can't just, start dealing with this stuff casually. What are the actual rules? Who can handle them? And how does the Director General figure out something like public interest when deciding on a license? That sounds a bit subjective.
That's a really good question because it definitely goes beyond just ticking technical boxes. For Group 1 and Group 3 substances, you generally need a license from the Director General to sell them, let them out, use them, operate them, apply them, or install them. For Group 4 substances, the radioactive ones we talked about, it's even stricter. You need specific written authority for activities like producing, acquiring, disposing of, importing, exporting, possessing, using, or even just transporting them. The Director General, or DG, specifically the Director General for National Health and Population Development, looks at these applications based on suitability, sure, but also the applicant's actual ability to control the activity safely and, crucially, that public interest factor. Now, assessing public interest isn't like a simple checklist. It involves weighing potential benefits against the risks to the community, thinking about environmental impact, and looking closely at the applicant's track record and their proposed safety plans. It really means diving into their business practices, checking they understand the risks, and seeing what measures they'll put in place. Licenses aren't always permanent either. They can be for a set period and need renewing, so there's ongoing oversight. They definitely are just rubber stamps. There's real scrutiny involved when deciding who gets to handle these potentially dangerous materials.
Okay, so there's a real emphasis on judgment and responsibility there, not just technical specs. It makes total sense that the people involved, their character and practices, are as important as the substance itself. But okay, once these substances are out there, licensed or authorized, who makes sure the rules are actually being followed? Who's the boots on the ground?
Right, that takes us to enforcement and oversight, and yeah, it's a vital piece of the whole system. The Act gives pretty significant powers to inspectors. These inspectors are appointed by the Director General, often for specific groups of hazardous substances. And it's not just health officials. These powers can be given to officers of customs and excise, employees of local authorities, even police officers above a certain rank, particularly when dealing with Group 1 and 2 substances. So it ensures pretty wide coverage. And these inspectors, well, they have quite broad powers. They can enter premises, they can inspect and search, they can take samples. Although for Group 3 and 4, it's often more about inspection and checking documents. They can demand information, weigh things, count things, measure, mark, or even seal up substances or their packages if needed. They can even place an embargo on a substance or an object. That means immediately stopping it from being exported, sold, dumped, or used if they suspect something's wrong. And if things look really serious, they have the power to seize items they suspect are involved in an offense against the Act.
Wow, that's some serious authority. It means there's a proper system for active checks and, crucially, immediate action if safety looks compromised. They can literally stop dangerous stuff in its tracks.
Exactly. And that active monitoring can start even before some substances properly enter the country. Which brings us neatly to import control.
Ah, okay. So what about hazardous stuff coming into the country? How does the Act manage those risks right at the border?
Yeah, this is a really critical control point. The Act has specific rules for imported substances. If substances arrive and, say, Customs holds them because there are worries about compliance with the Act, the Director General can step in. The DG can allow those goods to be moved to an approved holding area for proper examination or analysis. Now, if they find the substances don't meet the Act's requirements, the DG has a few options. They can order them to be confiscated and destroyed, or they can order them sent back to where they came from. Or maybe they can allow them to be imported, but only under strict conditions, like forcing them to put on new, correct labels or use specific packaging to make them safe. It's basically a preventative measure, trying to stop harmful materials getting into circulation in the first place, or at
Hmm.
least making sure they're made safe before they do.
Okay, so we've got this pretty sophisticated system, licensing, active inspections, border controls. But, rules are rules, and sometimes people break them. What happens then? What are the legal consequences if someone steps out of line? And importantly, are there protections built in for people who might be accused?
Right, the Act definitely lays out a clear framework for accountability, but it tries to balance penalties with due process. It lists numerous offenses. These range from things like obstructing an inspector or giving false information, right up to misrepresenting yourself or breaking the core rules. And the penalties are designed to be a serious deterrent. They can include hefty fines or even imprisonment. For instance, breaking the really strict rules for Group 4 substances, or maybe using a fake warranty to sell something that could lead to imprisonment for up to 10 years. Even things that might seem less severe, like obstructing an inspector, can still carry significant fines or jail time, maybe up to 12 months. The Act also has some important bits on liability. For example, if something's sold in a sealed package, the person whose name is on the label as the importer, manufacturer, or packer is, well, presumed to be that person legally. And perhaps more significantly, an employer or principal can actually be held liable for offenses committed by their employee, or even someone acting on their behalf, what the law calls a mandatory. That employer is liable, unless they can prove they took all reasonable measures to prevent the offense and didn't actually permit it. So the burden is on them to show they were diligent.
So it's not just the individual person pulling the lever, but potentially the whole company or organization that's accountable. That's a pretty strong incentive for businesses to really embed safety practices, isn't it? But what about fairness? Are there ways for someone accused to defend themselves?
Yes, absolutely. To balance things out, there are special defenses included. For example, if someone's charged with selling or importing a Group 1 or 2 substance that doesn't comply, they can defend themselves by proving they got it under a valid written warranty. Now, that warranty has to meet certain criteria, like being given by someone resident in the Republic, and it has to basically guarantee the substance isn't prohibited under the Act. It offers some protection if you rely on a supplier in good faith. And also, if the Director General makes a decision, maybe refuses a license or puts a condition on it and someone disagrees strongly, there's a way to challenge it. Any person who feels aggrieved can appeal to the minister. The minister then has the power to look at it again and can confirm the DG's decision, set it aside, change it, or replace it entirely. It provides that crucial check and balance against potentially arbitrary decisions. And finally, just touching on the legal process, in court, certain presumptions help the prosecution. For instance, a certificate or report from an official analyst is considered prima facie proof, meaning it's accepted as fact unless evidence proves otherwise. Also, if you're found manufacturing or importing a grouped hazardous substance, the law presumes you did it for use within the Republic, unless you can prove you didn't intend that. It just simplifies proving certain elements in court.
It really sounds like a well thought out legal structure. It's not just about punishing people, but also pushing for responsible behavior while still making sure there's due process and ways to appeal. It's quite comprehensive. But look, a law from 1973. The world's changed so much since then. How does an act like this stay relevant? How does it cope when new substances, new technologies pop up constantly, bringing risks nobody imagined back then?
Now, this is probably the Act's secret weapon for staying relevant over such a long time. The minister's really broad regulatory power. This is laid out in Section 29. The minister can make new regulations covering almost every single aspect of hazardous substances. They can authorize, regulate, restrict, or even completely prohibit manufacturing, importing, storage, transport, dumping. They can set rules for labeling, packaging, safety standards. They can even prescribe the fees for licenses. This huge flexibility means the Act can tackle new and evolving hazards without needing Parliament to pass a whole new amendment every single time. That would just be far too slow to keep up. And what's really commendable, I think, is the built-in commitment to involving the public. Generally, before the minister makes new regulations, they had to publish a notice about it in the Government Gazette, and then they have to invite comments and input from the public, usually for at least 3 months. This process ensures transparency and allows industry and the public to have their say. Now, there are exceptions, of course, if there's an urgent public interest need for immediate action against a sudden new threat, but the default is consultation.
So it's genuinely a living document then. It can be fine-tuned, adjusted based on new science, new threats, and public feedback. That's a really powerful feature for a safety act designed to last, allowing it to respond proactively.
Absolutely. And it's not purely a top-down national thing either. The Act specifically allows for the administration of its provisions by authorized local authorities. The minister can actually delegate powers to local councils or municipalities, letting them enforce specific parts of the Act within their own areas. This can include the power to prosecute offenses, and often any fines collected from those prosecutions go back to the local authority. This decentralizes the enforcement, makes it potentially more responsive to local issues, and tailors it to community needs.
Right, so local communities can be empowered to be guardians of safety in their own patch, too. That brings enforcement much closer to the ground level.
Precisely. And one final important point. The Act operates in addition to, and not in substitution for, other laws that are in direct conflict with it. What this means is it adds another layer of protection on top of any existing safety laws or regulations. It doesn't replace them. It strengthens the overall safety net rather than taking anything away. It helps build that robust infrastructure we rely on.
Wow, okay, what a deep dive that was. From that really careful sorting of hazards into groups I through 4 to the tough licensing rules, the vital work of those inspectors on the ground, and those really adaptable regulatory powers, the Hazardous Substances Act of 1973 really is a truly comprehensive piece of legislation. It stood the test of time.
It really has. And this act, although maybe not many people know its name, it underpins so much of the safety infrastructure that we just take so granted. It clearly shows how these legal frameworks translate directly into tangible protections for all of us, for public health. It impacts everything from the stuff on supermarket shelves to the complex medical procedures we might rely on. And what's truly remarkable, I think, isn't just that the Act exists, but that a law written way back in 1973 was so incredibly prescient. It wasn't just focused on, say, chemical spills. It actively anticipated and laid groundwork for managing risks from technologies like X-rays and microwaves, dangers that were only just starting to emerge then. That kind of forward-thinking resilience is something we maybe don't often credit to legal documents.
That's a great point. So, what does all this mean for you listening? Well, as you go about your life, surrounded by manufactured products and complex tech, maybe just take a moment to consider these unseen layers of regulation, like this act. It really makes you think about that constant balancing act, doesn't it? Between allowing innovation and progress and ensuring robust safety for everyone. This deep dive into a law that's now over 50 years old shows how legal frameworks can be designed to anticipate the future. But it leaves a question, doesn't it? How do you think regulatory bodies today should best handle the new emerging risks, things like AI, or maybe new genetic technologies? How do we foster progress while managing potentially hazardous developments? Something to think about. That's all for this deep dive. Until next time, stay curious, stay informed, and please stay safe.